in accordance with the submissions that we receive, that in many instances, an underlying condition will actually only come to the attention of the court if a witness gives evidence. So, to address this, an amendment is proposed to subsection 5. The current subsection states that the court must record his failure for non-appointing an intermediary. We renumber the current subsection 5 as 5A, and we aim to introduce a new subsection to the effect that the court may, if new circumstances come to his attention, that he may review or reconsider his refusal to appoint an intermediary. Clause 2 and 3 deals with bail, and it relates to bail by the South African Police Service. That's in terms of Section 59 of the Criminal Procedure Act, and Section 59A of the Criminal Procedure Act, where the National Prosecuting Authority can give bail. Submissions were received to the effect that mainly in respect of Section 65 of the Criminal Procedure Act, certain factors were not included. That is very relevant to, amongst others, GBV, and to also bring it in line with the revision of other bail provisions in the bill. And that is the fact that the accused, or rather whether the accused has committed certain offences while he was on parole, day parole, or under correctional supervision. The current Section 65G only deals with bail, and this additional considerations is not included in that provision. So amendment is therefore proposed, and we aim to amend, or rather propose to the committee, an amendment to Section 65G of the Criminal Procedure Act to the effect that the current paragraph G thereof be extended not only to include bail, but that the words that appears on the slide, on parole, day parole, or under correctional supervision, be included in paragraph G. Paragraph G, or rather Section 65G, deals amongst others with considerations that a court must take into account whether an accused person poses a risk to other persons when the court consider his or her release on bail. And the considerations are, amongst others, a Schedule 1 offence, and then an offence against a person in a domestic relationship, as well as contravention of certain orders of a court. Clause 5 of the bill deals with the cancellation of bail, 68 of the Criminal Procedure Act. The provisions are supported by most of the commentaries, and the department will not propose any amendments. There were also no substantive recommendations regarding amendments in this regard.
Sorry, Mr. Roberts. I'm getting complaints that certain members have not received this presentation. When are you sending this presentation?
Problem is, it's on my desktop. I have to copy it and then email it. I can try to go out and send it through, but I have to stop for a while then. Wait a minute. Thank you, Mr. Chairperson.
Can we give you 2 minutes to do that, so that everybody can have the presentation?
That's fine.
Thank you, Chairperson.
Chair, it's Wilma. Chair.
Honorable Trachans.
Yes, thank you, Chair, for that intervention, because really it is unfair for the department to expect us to go through a document that we have not received. It is incredibly unfair. And, you know, for me, as I've explained, I have the sign language interpreter as well that I need to put on my screen. And it's something that I've repeated so many times in this meetings, but the department still does not take that into consideration. Really, please. Thank you, Chair.
Thank you very much, DJ. Acting DJ. Can you hear us?
I'm sorry, Chair, I was just struggling to get to the screen. Yes, Chair, this is a document that we worked on overnight. I have requested Mr. Robertson to send the document urgently, but he said he couldn't do so because he was already talking to it. While we are dealing with this document, Ms. Ross is going to send the second document that we will be talking to after this presentation.
So we will give you the 2 minutes so that the documents can be sent.
Yes.
There are ground rules that we generally should always abide by. Is that even if you finish the document late, but members should have the document before they come to a meeting. Members should never be ambushed to have a document presented that they do not know. And these are the things that we do not want to spend the time of the meeting addressing. They are very basic.
Mr. Chairperson, I did send it to Vonani. Just want to confirm that you did receive it.
So let's have a 2 minutes break. What's the time now? Let me go out. It's 9:30. At 9:32, we will start.
Mr. Roberts, it's Sia here. Can you also send it to me, just in case maybe Bonani has internet problems on his side? Because I'm away.
Yes, I'll do that.
Yes, can you just copy me, because I'm in the meeting. I can quickly confirm that if we've received it, then I'll forward it to members. Because Bonani he's got serious network problems. Bonani has serious network problems, so I don't even, he comes in and out of the meeting, so he can send it to me. Thanks, sir.
So I also sent the document to you. So let's see if you received it.
I'm sure it's still on its way, Mr. Robinson. I haven't received it.
S.
Chair, Wilma has her hand up.
Yes, Mr. Offences.
Chair, thank you very much. So that we don't waste time, perhaps we can continue and then we'll get the email while we're in progress. Just like to make that suggestion. Thank you.
Thank you very much. We can communicate with the department so that the document is emailed to members whilst we are proceeding.
Chair.
Thank you. Mr. Roberts, can you proceed?
Thank you, Mr. Chairperson.
You
Was
seem
it clause 5?
You seem to have flu. Are you fine?
Sorry?
You seem
I
to
am.
have flu. Oh, okay.
Which
Okay.
document is it?
You can proceed.
It's a document number 1. That's the one that's currently on the screen. The other one is the revised comment and responses document.
This one. No, on the last. Check this one.
Can I proceed, Mr. Chairperson?
Please proceed.
Huh?
Clause 5 amends Section 68 of the Criminal Procedure Act, and that deals with the cancellation of bail. As can be seen from the comment and responses document, most of the commentaries or commentators support the provisions, and no amendments that are relevant to the objects of the bill is proposed. There is, however, a comment that was made, I think it was by Western Cape, that deals with additional amendment to Section 68. It's our submission that that amendment is outside the objects of the bill. It may be affected or it may not be affected. It's actually in the discretion of the committee. But insofar as it relates to the objects of the bill, it has not been considered. Clause 6 deal with criminal proceedings. Must take place in the presence of an accused person. What is addressed by Clause 6 is mainly evidence by electronic media, as is provided for in Section 158 of the Criminal Procedure Act. Commentators support the clauses. There were no substantial amendments to deal with this. So the department is not proposing any amendments in that regard. Clause 7 deals with witnesses to testify viva voce. Sorry, I duplicated the clauses. It's Clause 7 relates to Section 161 of the Criminal Procedure Act. It's a typo there. And the amendments that were affected in the bill is mainly to the effect that the persons that can testify otherwise is further clarified. The terminology of deaf and dumb is removed from section 161 of the Criminal Procedure Act, and it is substituted with the words lacking sense of hearing, no ability to speak, and it also then provides for certain persons with a psychological, physical, or emotional condition to communicate otherwise. Like I indicated, there's no substantial amendments proposed in this regard. Because I deal with intermediaries, section 170A of the Criminal Procedure Act. Most of the commentators are fine with this. I did discuss previously in respect of section 51 A and 37A of the Magistrates Court Act and the Superior Court respectively, that there is certain amendments relating to additional means to allow witnesses to communicate. And I did indicate that the intermediaries is not the appropriate functionaries for this regard. And that is mainly due to the fact that the new technology is quite extensive and you really need experts to ensure that the witness can use such technologies. Clause 9 deals with the right of a complainant to make presentations in certain matters regarding the placement of parole, day parole, or where a person is under correctional supervision. The clause amends section 299A1 of the Criminal Procedure Act. Although the clause is supported by various, or let me say almost all the commentators, a question that is asked is the new inserted paragraph H that states that the court must inform a complainant where the court imposes a period of imprisonment of more than 7 years in respect of offence against a person in a domestic relationship. The 7-year period was, amongst others, challenged by the Legal Aid Board of South Africa, or rather Legal Aid South Africa. They say it's probably not necessary. It's fine if it's just direct imprisonment. Various other persons also criticize it and ask about the necessity of 7 years, whether it cannot be a period of less than 7 years. So that is probably something that needs to be clarified, but it's the department's submission. If you look at the provision in question, section 299A, the offences currently listed in that subsection are, amongst others, offences like rape, murder, and various other serious offences. So, by determining a period of imprisonment of 7 years, we'll more or less bring it in line with some of the offences. We originally, when we developed the bill, suggested a period of 10 years after consultation with stakeholders. It was the period was lessened to 7 years. So, although all the commentators agrees with the thing. The only issue to be determined here is the 7 years imprisonment in respect of certain, or rather domestic related offences. Clause 10 deals with appeals against sentence of the superior courts. Means section 316B of the Criminal Procedure Act, although it's stated in the headings that it is 316A, it is actually 316B of the Criminal Procedure Act. The clause in question provides, amongst others, that the state may appeal a sentence that is changed by a superior court, and the state can then further appeal it to a higher authority. Most of the commentators are fine with the provision in question, and they are of the opinion that yes, it actually ensures that courts are accountable for their actions, to impose adequate sentences, to address gender-based violence type of offences. But the Legal Aid South Africa, they rely on the judgment of the Director of Public Prosecutions versus Western Cape. And in that judgment, it was decided that a sentence of an accused person should not be increased after is sentenced by a trial court. The department is of the opinion, and we do rely on the authority of the Ramulefi judgment. It's an appeal court judgment that was delivered in 2019. That amendment can probably be justified on the basis of the narrow criteria on which the state may appeal such a sentence. And that is where a grave failure of justice would otherwise result, or the administration of justice may be brought into disrepute. So this is probably one area where, well, further research is probably an option, but we changed the law as it is for centuries, I can actually say. But we can try to obtain a legal opinion regarding the constitutionality thereof, but we're probably not going to get further guidance regard to whether this will pass constitutional muster or not. Department is of the opinion, yes, it is probably fine, but there's always a possibility that the court can decide otherwise and invoke the authority that is confirmed in the COP judgment. Clauses 11, 12, 13, and 14 amend Schedule 1, 2, 7, and 8 of the Criminal Procedure Act. And it firstly brings the definition of the assault in line with each other. And it also expands on the current definition in the schedules to broaden what must be regarded as assault for purposes of that schedules. All the commentators support the amendments, and the department is not going to suggest any amendments to deal with this. So that provisions is fine. Was 15, 16, and 17 meant the various schedules to the criminal, or let's call it the Minimum Sentences Act. It was 15 Amendment Part 1 of Schedule 2. That's sentences where a court must impose life imprisonment. It was 16 Amendment Part 2 of Schedule 2, and less serious offences is included in proposed clause 17. Regarding attempted murder was previously in Part 3 of Schedule 2. It was promoted to Part 2 of Schedule 2. And Legal Aid South Africa raised the question whether it's justifiable to actually include it in Part 2 of Schedule 2, due to the fact that murder that does not fall in Part 1 is also part of Part 2 of Schedule 2. And they did indicate that for murder, a court will usually impose a lesser sentence. Our justification for that is that in Part 1 of Schedule 2, a court may impose life sentences for aggravated murder. And attempted murder in respect of such offences is now dealt with under Part 2 of this schedule. The only problem is the current murder that is not aggravated, and it will apply to that equally. So this is probably one area that needs to be reconsidered. But we want to consultate with the National Prosecuting Authority in this regard before we suggest any amendments to the committee. Regarding life imprisonment, embrace prior. It is the opinion that rape and compelled rape, which is currently inserted in Part 2 of Schedule 2, is due to their severity not catered adequately. And they suggested that life imprisonment must be imposed in respect of rape and compelled rape, irrespective of whether the aggravating factors that is listed in Part 1 is present. Well, the submissions of the department is to the effect that we need to distinguish between aggravated rape and compelled rape and certain lesser degrees of rape. Deterrence and retribution is one aspect of criminal law. But obviously that's not the only objective of criminal law. And we must consider reform of possible perpetrators as well. To merely impose life imprisonment for rape and compelled rape will actually ensure that that persons cannot be rehabilitated or reformed and hopefully as good citizens be let out of prison. And it's our submission that rape and compelled rape that is not aggravated as contemplated in Part 1 of Schedule 2 is therefore adequately scheduled. Another thing that must be taken into account here is minimum sentences actually do take away a court's discretion to mete out punishment that fits the crime, taking into consideration taking into consideration the circumstances of the accused, and also to serve society. So if we take away the discretion of a court to deal with these aspects, obviously legislation should ensure that that is included in whatever provision is put in legislation. Although courts have a discretion to apply or not to apply minimum sentences, it is submitted that if the conditions are met for minimum sentences, that the court must impose them. So to impose life imprisonment for all categories of rape, it's probably can be challenged, and it's probably not something that is needed in a constitutional dispensation. Mr. Chairperson, that is the main areas. I don't want to say conflict between the department and the comments we did receive, but the areas that needs to be addressed if we want to take this bill forward. Thank you.
Thank you very much, Mr. Robertson. Thank you for the work done. I will now note hands from members. I know Honorable Breitenbach has indicated that she has a question. Can you remove your screen so that I can be able to see members?
I closed it. Is it still on? I'll close. Sorry, Mr.
Okay.
Chairperson.
Yeah, okay, now I can see the members. I have Honorable Breitenbach, I have Honorable Nomathemba Maseko Jele, I have Honorable Werner Hor. In that order.
Thank you, Mr. Chair. Good morning, everybody. Mr. Robertson, I'm not sure that I understood correctly, so perhaps you could just explain it to me again. The issue of attempted murder being dealt with in the same category of crimes as murder that's not aggravated murder. What seems to be the issue there?
Must I respond directly, Mr. Chairperson? I will prefer that.
Mr. Robertson, Mr. Robertson, I will indicate when you should respond.
Okay, well then let me finish. Sorry, Mr. Chair, let me finish my question to him then if I'm going to wait for an answer. Sorry.
Yes.
Then, you know, as I understood it, Mr. Robertson, there's an issue with dealing with attempted murder. It's not being as serious as murder that's not aggravated. But all attempted murder is somebody who was too slecht to actually succeed at murder. I'm not sure if they should be rewarded for that. Attempted murder and murder require the same elements of intent and etc. So I regard them the one as serious as the other. The fact that you failed miserably in your mission to murder shouldn't mean that you're treated more lightly than somebody who actually succeeded. I think they're equally serious. So perhaps you could discuss that.
Are you done, Honorable Breitenbach?
Thank you. Yes, Mr. Chair.
Okay, thank you very much. I thought that dog might have murdered you or attempted to murder you.
Oh, he's just noisy, but he's gorgeous.
Oh, okay. Honorable Nomathemba Maseko Jele.
Thank you, Chair. It's unfortunately because you are too far, you won't even help even if the dog can do that. Thank you, Chair. No, mine is just a clarity, Chair, on the issue of the definition of assault, where it says if a wound, it's a. In fact, I wanted to find out what would you be considering to be a dangerous wound, because they're saying here if a wound is dangerous. I'm not sure what does that mean, because to me a wound is a wound. There's no wound which is dangerous. There's no wound which is dangerous or not dangerous. A wound is a wound. So why would we say here if a wound is dangerous or not dangerous? Can I just get clarity there?
Thank you very much, Honorable Horn.
Thank you, Chair. My question is related to the comment made by Mr. Roberts that, and I'm paraphrasing his words now, that certain of the proposed amendments may ultimately fall foul of a finding of unconstitutionality, but the department seems to be of the view that they are fairly confident that it is not unconstitutional. And I want to say that I think that type of advice to the committee with respect is not really assisting us. I'm firmly of the view, and I trust that my colleagues would support me, that we have a duty, while strengthening the legislative framework dealing with the matters under discussion, we similarly have a duty to ensure that we uphold and protect the Constitution of South Africa. So I would want to ask that we get firm advice. I don't think it is proper for the department to advise Parliament as the legislature to make laws of which we are not confident that they will pass constitutional muster. Thank you, Chair.
Thank you very much, Honorable Horn. Mr. Robertson.
Thank you, Mr. Chairperson. In the comment and response document, insofar as it relates to section 316B, it does include the submissions of the department. Sometimes when you make law, and where there's established legal principles regarding something, and you change that long established legal principles to an extent, there's always a possibility that a court may, on the grounds of current authority, decide that you may fall foul of a constitutional obligation or encroach on certain constitutional rights. I think it happens frequently when legislation is made. On the one hand, you get Legal Aid South Africa that is more or less telling us that there is case law to the effect that that old legal principle is still applicable. The departments rely on a newer decision, which is to the effect that yes, we can go as far as changing the well-established legal principle. But until the Constitutional Court really clarify a position, there's no certainty. The State Law Advisors certified the bill constitutional. They consult, amongst others, with the National Prosecuting Authority. They are of the opinion that section 316B is constitutional in its amended form. But yes, there's two authorities in place. So on that basis, since our decision is the latest decision, and cannot say it's directly to the point, but it really did give a clear indication to the effect that it's probably, that it is preferable that such a power be given to the National Prosecuting Authority I will argue from my side that yes, the department is correct. Like I said, there is other judgment of the Supreme Court of Appeal in place that actually do confirm that long-standing legal principle. So it's not intentionally misleading Parliament. We did everything that we can do to ensure that we are correct and that whatever we bring before Parliament complies with the law. Like I said, there has not been a constitutional court judgment that tells you this is the position. So you have to rely on the ordinary principles, whether it's reasonable and justifiable in an open and democratic society in accordance with Section 36 to justify it ultimately. And that is probably as far as I can take that explanation. Regarding the question,
sorry, Mr. Roberts, can you go back to that slide? Maybe I read the slide incorrectly. The first decision was from the Cape High Court, is that correct? That the legal aid South Africa is relying on, and you are arguing that you are relying on the recent court judgment by the Supreme Court of Appeal, and there is no other court judgment that is from a court higher than the Supreme Court of Appeal, which would be the Constitutional Court, which according to you means that the binding judgment as of now is that of the Supreme Court of Appeal. Is that correct?
Chair, I think it's clause 10, and that's where he needs to go, what you are raising.
Yes.
It's about the Ramulifi case.
Yes, the Ramulifi case and the other one from the Cape High Court.
The DPP Western Cape, yes.
Yes. Can you hear us, Mr. Robertson? We seem to have lost him. Mr. Robertson?
Sorry, Mr. Chairperson, can you hear me?
Yes, we can hear you.
Sorry.
Did you understand my question? Did you get my question?
Both. Mr. Chairperson, the first judgment is that of the Western Cape versus the Cock. It's the Director of Public Prosecutions. It's an appeal court case. The second one is the Ramulefi judgment. Reference is 2019 ZA SPA 60. As far as I can remember, that's also an appeal court case. So,
can you take us to that slide?
Okay. This authority to share. Can everybody see it? Mr. Chairperson, can you see the slide?
Yes.
And the second one is Ramulefi judgment. In the slideshow, I do refer to the decided cases in that regard. And insofar as it relates to section 316B, if the committee wants further information in that regard, it is discussed there.
So you say that both judgments are from the Supreme Court of Appeal?
Yes. As far as I can remember, I read it 8 months ago, I think.
Then we might need to, as a committee, also to apply ourselves to what Honorable Horn has been raising when we deliberate.
Okay. Can I close sharing?
Yes.
I think it was right. Regarding the question of the Honourable Mrs. Breitenbach, that attempted murder is attempted murder. On one hand, you get the offence of murder with aggravating circumstances. That is in part 1 of Schedule 2, which really tell you that it's quite serious offences. And in Schedule 2, you get murder, which is not murder as contemplated in part 1 of Schedule 2. And in the same part of the Criminal Procedure Act, that's part 2, attempted murder has been inserted. The Legal Aid Board raised the question to the effect that you get a less serious form of murder, which is in part 2, and in the same schedule you get attempted murder. And both are subject to minimum sentences, and they refer to authorities to effect, and it's well known that a person who is convicted of attempted murder can usually receive a lesser type of offence than murder. I hope I clarify that. I do agree with you. Murder is murder and attempted murder is murder. You get degrees of murder and attempted murder. A possible solution will be to clarify the murder with aggravating circumstances with the words murder or attempted murder, so that it applies to the serious form of murder, and if you fail in your serious form of murder, that any attempt to commit that will in any case make yourself subject to a minimum sentence. You can move attempted murder in respect of part 2 of Schedule 2 offence to part 3, which is probably not a good solution. Alternatively, we can also in respect of murder in part 2 of Schedule 2 state that, or rather clarified as murder or attempted murder. That does not fall under part 1 of Schedule 2. That will solve it. I hope I could clarify that.
Maybe when you bring the text, bring those options to us when you bring the actual text of the bill, of the reworked bill.
Thank you, Mr. Chairperson. Currently in Schedule 7 of the Criminal Procedure Act, this relates to the question assault when a dangerous wound is inflicted. that has been inserted in the various new definitions that is now all included in most of the schedules of the Criminal Procedure Act. In Schedule 7, there was a definition of assault to the effect that it is when a dangerous wound is inflicted. It must not be an ordinary wound, it must be something more serious, dangerous, probably life-threatening. Probably something like affecting life or limb, but not as far as attempted murder. And what we did is, in respect of all the other schedules, we insert that in the Schedule 1 and the other schedules that is mentioned in the bill. So, in respect of the various definitions that's currently in the schedules, we get when a dangerous wound is inflicted, obviously, that has been interpreted by the court. So I think it is to the effect that, yes, it must be an open wound, it must be serious, it must harm you. Then there was various cases that was decided regarding the infliction of grievous bodily harm. And one of the concerns that were raised was that assault involving the infliction of grievous bodily harm is currently not in Schedule 1 of the Criminal Procedure Act. But grievous bodily harm has also been interpreted. There is the offence of assault with grievous bodily harm. And it may also involve something like a dangerous wound or an open wound. But yeah, that is the explanation I can give. When a dangerous wound is inflicted, it's obviously a wound. You can see
that. Can you
repeat? Bleed. Relating to the infliction of grievous bodily harm, that can be something else. It's like you give a person an overdose of sleeping tablets, as an example. Hope I explained that.
Mr. Robertson, did you hear me? I was saying that, can you repeat your response to Honorable Jelle?
Chairperson, the bandwidth is extremely low. Let's try again.
Yes.
Okay, first, a dangerous wound is clarified with respect to a wound, something that's open, you bleed. And a dangerous wound further prescribe the seriousness of the wound. Like I said, it appeared in Schedule 7 of the Criminal Procedure Act, and it is basically made applicable in addition to other considerations to further build on assault. So, why did we use dangerous wounds? We can use the wording open wound that is dangerous in nature. Or we can just say a dangerous wound that obviously connotes the meaning that it is a wound. You bleed, your body is damaged. And then I did explain that assault with the intention to do grievous bodily harm may not per se involve a wound. It can be something else. It's like where I give a person poison or overdose him with sleeping tablets. It's not a wound. Thank you.
Thank you very much. Any further questions, members?
Chair.
Honorable Zola.
I just want to make a follow-up. I'm sorry for maybe trying to follow up on this one this minute. I want to find out in relation to what we are talking about, GBV. Sometimes you find that a woman has been beaten. You find that the eye with fist, and then your eye tends to be red, and it looks very dangerous to a point that sometimes this person can hit you and you lose your eye. I want to know such wounds or such action. How would we classify them? Because are we going to leave this to the court to decide the decrease in that manner? Because we're talking about GBV here. Sometimes this man or a woman, I don't want to say men only, a woman can beat this person using maybe an object. You find that this person turns blue. We know with those internal wounds. How would we describe those wounds? Because it's like now, I'm not sure if maybe I hear him properly when he says it is a wound that is open. Maybe I would suggest that maybe blood is coming out. Then that one, it's clear, it's a dangerous wound because you're going to lose your blood and all that. But where in a case where you don't lose a blood, you don't lose blood and your eye is red and all that, how would you categorize that one? Thank you, Chair.
Thank you very much, Honorable Mufute.
Thank you, Chairperson. Chair, I just want to check on clause 9, right of complainant to make presentation in certain matters. I can see that the department says the amendment is mostly supported by the commentators as indicated in the comments and response document, and shortcomings in respect of parole must be addressed in terms of Correctional Services Act and not the CPA section 299A. But then when you go down, it says that it's clear that various commentators question the 7 years qualification. Can they tell me if there's no one in the submission who came with a suggestion of years? Because I remember there were suggestions of years. That is my question. And also, what are they advising us? Because it has been said many times on the parole issue must first be addressed by the correctional services. Thank you, Chair.
Thank you very much. Mr. Robertson.
Thank you, Mr. Chairperson. When we changed the definitions of assault in the various schedules of the Criminal Procedure Act, we did take the example into account where a person is really seriously injured, but there is no physical evidence thereof. It's obviously you break somebody's arm, there's no wound. But that will qualify as assault with the intention to do grievous bodily harm. My submission, a wound is to the effect that it's a visible injury that is affected to somebody's body. If it doesn't qualify as a visible injury, it will qualify at least as assault with the intention to do grievous bodily harm. So with regarding to a red damaged eye that is full of blood, there's no blood that's seeping out, one can probably argue, yes, that will qualify as assault with the intention to do grievous bodily harm. So both situations is covered in that regard. Regarding the that was not part of. Sorry, Mr. Chairperson. I believe during public hearings, there were a suggestion by the Catholic Church that the period must be between 4 or 5 years. If you look at legal aid South Africa, their submission is to the effect if there's direct imprisonment, it is fine. And yeah, that is the sum total of suggestions that we got. But I did explain, one must look at section 299A of the Criminal Procedure Act and see what is currently in the clauses. And I did indicate it's relatively serious offences. Well, it's up to Parliament to change it. I don't think you can, with reference to what is currently in section 299A1, say that, yes, let's determine something that's in line with what is currently there. That cannot be done. So we need to find a middle point. Obviously, on the one hand, it is offences in a domestic relationship. Some of that offences will qualify as serious offences, amongst others. Rape may go as far as the killing of a person. Obviously, in instances like that, there's no problem. But you do get certain offences that's probably less serious in nature, committed against somebody else in a domestic relationship. And let's say the court imposes something like 6 months direct imprisonment for the sentence. Or let's rather say a year, since the parole board is usually involved. Then, yeah, that is, we're stuck with that problem. Cannot determine it too low, since it's subject to parole proceedings. We cannot determine it completely in line with what is currently in section 299A of the Criminal Procedure Act. Further research will be done in this regard, and we will submit either amendment with motivation to further deal with this, or if we cannot come up with a solution, further consult with people on an urgent basis to see what we can come up with if the 7 years imprisonment period is not acceptable. Thank you.
Before I allow Honorable Breitenbach, because I saw her hand, we have been dealing as the committee with a complaint against a magistrate in KZN who imprisoned or who sentenced a father who raped his child to 5 years imprisonment. And there are allegations of other sentences that were generally horrifying. So you would always find that in the magistrate courts, you have such sentences where for serious offenses, people are given very low sentences. I think the issue raised by Honorable Mfugeng also was around that. Now, if we are going to use 7 years, what if the magistrates has imposed a very low sentence, but was not appealed or reviewed for something that is reasonably serious. So I think that is the balance that we would want to create. Cases in the magistrates court are not reported cases, unlike in the high courts, but majority of the cases that people are dealing with every day end up in the magistrates court. So I think we need to find that balance.
I acknowledge that. That is correct. We need to find the balance.
Yes, thanks you very much. I noted Honorable Breitenbach.
Thank you, Mr. Chair. In retrospect, having thought about it, I think what I need to say, I'll say to the committee when we're meeting as a committee.
Okay, thank you very much. Just before we proceed, Honorable Horn, having received the response from Mr. Roberts about the case, the issue of the appeal, what are your initial responses? I know you might want to ventilate it further when we discuss it in the committee, but having received the response, what is your initial reaction?
Yeah, Chair, I think we are in respect of that specific proposal, but even some others in some of the other bills, I think we will have to embrace the duty to ensure that we pass constitutionally compliant legislation. So if I may abuse the opportunity as well, Mrs. Botha yesterday also referred to a constitutional court case which had an effect or an impact on the ability of to, for example, make regulations. And I didn't write the specific case down at the time. So if I may abuse this opportunity to ask that the case or the reference be sent to us so that we can also study that. And yes, Chair, we can deliberate on it further when we as a committee discuss this, but my strong feeling at this stage is that we must also, as members of Parliament, possibly ask Parliament's legal advisors for advice on those specific sticky issues where it is not clear-cut that what is presented to us is necessarily constitutionally compliant. As another form of safeguard, it is so that hopefully courts going forward in assessing the validity of what we pass will also take note of the fact that this has been done in an attempt to once and for all, in a very material and serious manner, address the scourge of gender-based and sexual and domestic violence. But at this stage, we can't just accept that will necessarily be the view of the courts, and we must find a way to at least, as members of Parliament or as Parliament, say that we've done what we had to do to ensure that we do not expose the legislation to findings of unconstitutionality. So that's my initial response. So thank you, Chair.
Well, thank you very much. Can we, at least by Friday, as various parties here I think by Friday we would have gone through all the submissions, try to consolidate issues or areas where we think that we might need to have a legal opinion, so that by the time the department comes, already we have procured the legal, in fact, the opinion of either the parliamentary services or the senior counsel, so that we try and deal with the issue of time. So I do think that by Friday we would have a sense of the areas that we think that might need legal opinion, but we can't do them bit by bit. I think we need to consolidate them into, so that even if we get an outside legal opinion or even a parliamentary opinion. It is on the basis of all what we would have consolidated as the committee.
Yes,
Can
thank
we-
you, Chair. We will do that.
Thank you very much, Honorable Drachen.
Thank you, Chair. Thank you, Chair. Yesterday, I typed in the chat box for the link to the department's research regarding the age of 25 and the brain's development, what they mentioned yesterday. So if the department could also send us the link to the research that they used in developing the bill. Thank you.
Thank you. Thank you very much. I think for Mr. Roberts, that will be all for the presentation. I think, Mr. Roberts, I think you have done a good job. I think the department has done a good job. I think in areas where there's a need for various options to be developed, please do that. But I think you can proceed to give us a text that we can work on. I think it does assist us to formulate our views. I think even in areas where we disagree with you, we have tentative views about why and where are we disagreeing with you. I think it does assist us to really apply our mind to the bill. I think it's a job well done. So we'll be expecting when we start. I think early next week that at least there is a bill with all the options that were raised here, where you think that there might be different options and there might be differences of opinions, create options so that we can apply ourselves to those options.
Thank you. No, it will be ready. Thanks.
Thank you very much. The next presentation. So are we done with the bills? Are we going back to the yesterday's presentation? Acting teacher.
Chair, Delene Clark is going to flight that presentation. Delene, are you ready?
Which one is that, teacher?
That's the one on the domestic violence, Chair.
That is the yesterday's one.
Yes, that's yesterday's one. We've also sent the summarized format of the document through to Sia, and Ms. Clark will now flight that presentation.
Members, did you receive? Have you received the summarized version, or what was sent to you yesterday?
Yes, we received it, Chair.
Thank you very much.
Oh, we got it.
Thank you very much, Acting Teacher. You can proceed, ma'am.
Good morning, Honourable Chair. Just by way of introduction, it's Delene Clark here. And just by way of introduction, I'd just like to say that there's been an overwhelming support through the majority of the submissions in favour of the amendments to the Domestic Violence Act. The police were in the meeting yesterday and have indicated their support of the bill. We will be having a collegial bilateral meeting tomorrow morning. But in essence, the majority of the comments that they had really spoke to flow and clarity, and they're not opposed to the bill. So the document has been substantially condensed with reference to the larger collation of submissions, and Mr. Mokulubeti will now take us through the substantive submissions. Thank you so much.
Morning, Honourable Chair, and good morning, honourable members. I just hope, Chair, the presentation is visible to everyone. It is, sir. Thank you. Yeah. Chair, I will cross-reference to the initial or the main bundle.
for the purposes of having a fuller discussion in respect of each aspect. And obviously then we will be focusing on the main aspects that we need to address and deal with for today's purposes. Starting from page 25, we have received a submission from the Warrior Project, where they were suggesting the insertion of the words education expenses between the words including and household expenses in clause 1JA. Chair, our response to that is that although education expenses are covered under the expression economic and financial resources to which a complainant or related person is entitled under law, this item could be listed as it actually impacts directly on the children in the home. Essentially, we are in support of the inclusion of this education expenses in clause 1JA. Chair, the Warrior Project further submitted suggestions in relation to the definition of emotional, verbal, and psychological abuse. The submission is contained in page 29 of the main bundle. Chair, for completion's sake, I would like to read out what the provision currently states in the bill. The emotional, verbal, or psychological abuse means degrading or humiliating conduct towards a complainant or a related person, including a insult, ridicule, or name calling, B, threats to cause emotional pain, C, the exhibition of obsessive possessiveness or jealousy, which is such as to constitute a serious invasion of the complainant or related person's privacy, liberty, integrity, or security, or D, inducing fear. Now, the suggestions that we have received from the Warrior Project as contained in page 29 is to substitute the words emotional pain with the word harm in clause 1B. And clause 1B reads threats to cause emotional pain. So the suggestion is to replace emotional pain with the word harm. For the clause to read threats that cause harm. Honorable Chair and honorable members, the term harm is defined in the bill, and the department is in support of the suggestion in relation to the substitution of emotional pain with harm. Further submission, Chair, relates to the insertion of the word manipulating between the words degrading and or humiliating for the provisions to read emotional, verbal, or psychological abuse degrading, manipulating, or humiliating conduct. The definition.
Sorry, Chair.
Honorable Chair.
There's something that we've been missing. I'm not sure if maybe it's me alone. I've missed some information when he was talking because it seems as if there's something wrong with the gadget. I don't know whether it's mine. You will clarify, Chair.
Yeah, I think his bandwidth is low. Maybe if you can repeat the previous clause that you are talking to, we will be able to catch up.
Indeed, Chair, I will do so. Chair, the submission by the Warrior Project is to insert the word manipulating between the words degrading and or humiliating for this provision to read emotional, verbal, or psychological abuse means degrading, manipulating, or humiliating conduct towards a complainant or a related person. And our response to that, Chair, is that the proposal is supported, and the word manipulating can be inserted in the definition of emotional, verbal, and or psychological abuse as suggested by the Warrior Project. Furthermore, Chair, is a proposal for the insertion between paragraph B and C, the insertion of the term gaslighting as paragraph C. And this gaslighting must in turn be defined to mean manipulating a complainant by psychological means to cause a complainant to doubt his or her own sanity or memory. Chair, I just mentioned that the department supported the insertion of the word manipulating, and as a result, the insertion of gaslighting is not supported, as it will not be necessary to do so due to the inclusion of the word manipulating. As a result, the opposition is not supported. Chair, the Legal Resources Center has made submissions. Regarding the definition of sexual abuse, the suggestion is to include sex-based harassment, which in turn should be defined to read unwanted verbal, written, or physical conduct based on a person's sexual orientation, gender expression, or a physical appearance. Chair, in terms of the bill, there are definitions that include sexual abuse and sexual harassment. However, the consideration should be given to the inclusion of this proposition in the definition of sexual orientation. However, it should be refined specifically to refer to sexual orientation, gender expression, or physical appearance. And this should be under the definition of sexual harassment. Chair, the second point that is raised by the Legal Resources Center is to include unwelcome, explicit or implicit behavior, suggestions, gestures, messages, or remarks of a sexual nature, including a person's sexual orientation, gender expression, or physical appearance that have the effect of offending, intimidating, or humiliating the complainant or a related person. Chair, our response to that is that the proposal is not supported because it is covered by the definition of the sexual harassment as defined in the bill. Chair, the further submission is in relation to the definition of sexual harassment. If I may move the presentation up. The observation is that the definition of sexual harassment includes under paragraph B, unwelcome, explicit or implicit behavior, suggestions, etc., towards the complainant or a related person that have the effect of offending, intimidating, or humiliating the complainant. And the submission is that the proposed definition requires that the complainant himself or herself, and not the related person, must reasonably be offended. They submit that this requirement is not provided for in any other forms of domestic violence as discussed above. That is in relation in the main submissions. And essentially, their submission is that the complainant, who may not be even be present or aware of the behavior or suggestion, if it has been made to a related person, should be offended. Essentially, in a nutshell, they are of the view that the provision refers to a related person. However, the person who is to be offended is the complainant. Chair, our response in a nutshell is to point out that the inclusion of this term in this particular provision is misplaced in this definition, and the department is inclined to have this related person removed, particularly from this paragraph. A further submission, Chair, is in relation to clause 2A of the bill. And the submission is to the effect that clause 2A that we are introducing in the bill places a duty on a functionary who, in the course of the performance of his or her functions, becomes aware that a child, person with a disability, or an older person, or an adult is a complainant of domestic violence, must report this to a social worker and the South African police. The submission further is that as a result, the functionary that is referred to in the clause will be required to have the knowledge of the ambit of the Act itself, particularly in relation to what constitutes domestic violence, and also who exactly is a complainant. And this is especially in view of the proposed expansion of the definition of a complainant beyond the persons in a domestic relationship. Furthermore, Chair, the submission is that this provision invites matters to be reported to the police, which matters are not domestic violence related matters, or where a person who is involved in that matter does not fall within the ambit of the definition of a complainant. Chair, the department, I must say, is swayed in favor of removing the provision relating to the mandatory reporting. And this is based on the negating of a woman's autonomy and the risk to her safety and her support network. This mandatory reporting check could further place an adult in danger where she is not notified that her particular matter has been reported, and as she has had no opportunity to put a safety plan in place. Furthermore, Chair, the provision could further place an adult in direct danger where she is not notified that the matter has been reported and she has not had the opportunity to put a safety plan in place. My apologies, Chair, I see it must be a repetition there. Chair, the listed functionaries are defined. And in terms of the bill, section or clause 18B provides for the issuing of the directives by the various DGs of the various departments, which will including the training on the Act itself. Chair, in some instances, a matter may be referred to the police where it does not actually constitute a domestic violence or an offense. However, the view of the department is that it is better to err on the side of safety when it comes to vulnerable persons, such as children, the elderly, or persons with a disability. Furthermore, a multidisciplinary approach will ensure that matters are referred for the correct intervention to the correct functionaries, and in terms of the applicable law, which may in certain instances not be the Domestic Violence Act itself. However, Chair, where it does not constitute an offense, but the circumstances allow for an application for a protection order, the complainant should be assisted as best as possible to make such an application. In addition to the provision submitted by the commentator, which appears on page 45 in relation to this clause, the proposition is that, or the observation is that the proposed subsection 3 requires the functionary contemplated in section 2A1 to, if the complainant is an adult person, report the matter to a social worker or the South African police in the matters referred to in subsection 2. Must be reported to both, or while matters referred to in subclause 2 must be reported to both the social worker and the police. So, Chair, the concern is in relation to the differentiation between one clause requiring that the matter must be reported to the police and the social worker, whereas in other instances, the matter must be reported to the social worker or the police. And as a result, Chair, we noted these differentiations, and as a department, we are in support of the removal of the word and replace it with or in clause 2A, 2A, Roman figure 2. And this we are doing so as to not require a report be made to both the social worker and the police. Chair, further submissions are received in relation to clause 1, where that in clause 2A1A of the bill uses the words becomes aware of the fact. Also, 2A2 refers to clause 2A1A, but refers to knowledge. In fact, Chair, what they are saying is that in one provision, we are referring to a word fact, and on the other provision, which clause refers to the previous one, we're referring to knowledge. So there's a difference, a use of terminology there, which the representatives submit that may create confusion, especially to the extent of the knowledge of domestic violence, which is prevalent. We do not need to have differentiations that cannot be reconciled. And as a result, Chair, a revision of the clause is proposed by the commentator, and our response as the department is that the resolution or the conclusion by the department to support the deletion of the provision dealing with the mandatory reporting in relation to adults, the department suggests that the clause, especially clause 2A, 1, be revised. And Chair, we have provided the possible or a suitable provision in replacement of that. So the revised provision, Chair, will read: a functionary who, in the course of the performance of his or her duties or the exercise of his or her function, has knowledge, reasonable belief, or suspicion that a child, a person with a disability, or an older person is a complainant as contemplated in section 1, must comply with subsection 2. Chair, in light of this proposal, there will be consequential amendments that needs to be made to the clause, and those will be taken care of. Chair, the further submission in relation to the very same clause 2A, where the submission is that this clause read together with the provisions proposed by clause 18B. Clause 18B deals with the introduction or the issuing of the directives by the DGs of the various departments. Is an important step. That is the submission of the role player towards creating a more comprehensive, multi-dimensional response to domestic violence. The provisions obliging functionaries to report cases of a suspected or known domestic violence must, however, be qualified in relation to children, older persons, and people with disability. Chair, in response, we are in support of the proposal in relation to alignment of the mandatory reporting in respect of children, the elderly, and the persons with disability. And this alignment will be in relation to the Children's Act and the Older Persons Act, and also a redrafting of the definition of a disability will be taken care of. The proposed section 2A will also be amended to deal with child victims in accordance with the Children's Act, and with the retention of the directive to provide additional services for child victims. Chair, the further submission on this very important clause is to the effect that the recommendation is made that a reference to a person with a disability in this clause be substituted for the following expression: A person who presents with a physical, psychosocial, or intellectual disability that impacts on their capacity to make decisions. Chair and honorable members, as the department, we do not support this proposal, as it is restrictive to an extent that it excludes other types of disability. Chair, disability is defined in the bill to read: disability means a physical, mental, intellectual, or sensory impairment which prevents a person having such an impairment from operating in an environment developed for persons without such an impairment. Chair, if we look at the proposal that is made, and also in consideration of the disability as defined in the bill, it is the view of the department that that proposed insertion should not be supported. Furthermore, Chair, the proposal is made in relation to the omission of physical address in the list that must be provided to the complainant under clause 2A3B. And if I may read out, Chair, that clause, it reads as follows: where the complainant is an adult person as contemplated in paragraph B, the functionary must, if it is reasonably possible to do so, provide the complainant with a prescribed list containing the names and contact particulars of accessible shelters and public health establishment. Chair, you'll notice that the clause does not set out specifically a physical address, but the reference to contact particulars will include a physical address, which means therefore physical address will have to be included in the list. And the submission or the proposal is that there must be a provision that specifically excludes a physical address being included in the list. And the reason for that is to keep the allocation confidential to ensure the safety of the shelter users. Chair, the department is supportive of this proposal. And as a result, we have a strong provision that will cater for that. And we are doing this by way of a proviso, which will be included in the clause 2A3B, Roman figure 2, to read: provide the complainant with a prescribed list containing the names and contact particulars of accessible shelters and health establishments, provided that the list must not contain the addresses of the shelters and public health establishments. Chair, this is how we are incorporating the submissions that we have received in this regard. Furthermore, Chair, the submission in relation to clause 2A3 is to insert a further paragraph 4 to read: assist the complainant prepare a safety plan in order to help them avoid dangerous situations and to know the best way to react when they are in danger. Chair, we are of the view that, as the department, we are of the view that this should form part of the directives. A social worker will be a professional trained to deal with this, as we are of the view that it is not the functional or the responsibility of especially all functionaries to prepare a safety plan, as many of those functionaries may not have the expertise to do so. However, Chair, the paragraph C of the subsection does provide for referral for further services as may be prescribed by the directives contemplated in section 18B, which may involve a person with the required expertise. Therefore, the directives will deal with the proposed paragraph 4. Chair, a further submission in relation to clause 2A is to the effect that this clause add by treating older people and people with physical disability as if they were mentally or intellectually impaired. The submission is that, Chair, the wording a child, a person with a disability or an older person implies that all these three categories of people are unable to make informed decisions for themselves, when in fact only the child, it is only in respect of a child that these incapacities apply. Chair, in response, we are of the view that the clause is intended to protect those who are vulnerable, and even if they are able to make decisions for themselves, the provision will still be available for those who are not able to make informed decisions. Chair, we are of the view further that is that if we remove this expression, those who are in need of protection will be left without a recourse. Chair, there's a submission in relation to mandatory arrest. The submission is that the mandatory arrest for physical abuse may have unintended consequences, especially where a victim uses a defensive action causing physical abuse. And as a result, both will need to be arrested. And we are of the view, Chair, that the proposal of a mandatory arrest allows for the arrest of a person who is reasonably suspected of having committed an offense. Chair, this may be construed to apply to both parties where physical violence is involved. However, it could also be construed to apply to the primary action. As a result, a victim will not be arrested for defending herself. Failure to arrest, Chair, due to the discretionary power to arrest whether physical abuse, where there is physical abuse, could leave the victim in danger. And that will be our submission in relation to this issue of mandatory arrest. Chair, the further provision or submission is that there is no mention of an obligation on the part of the clerk of the court to ensure that interim orders and warrants of arrest are forwarded to the complainant's preferred police. And the submission is to include a provision to that effect in relation to interim protection orders. Chair, we are of the view that The submission has weight, and we are in support as the department of that submission, and as a result, we intend to, or we are in support of the inclusion of a provision to read that clerk of the court must immediately, in the prescribed manner, forward certified copies of a protection order and of the warrant of arrest contemplated in section 18(1)(a) to the police station of the complainant's choice, and this clause should be inserted as clause 5(3)(e). The result of this, Chair, will be that when there is an interim protection order issued by the court, then the hard copies of that, of the protection order and the warrant, must be submitted to the police station of the complainant's choice, in as far as that is the case in relation to the final protection order. Chair, there is a submission that the interim protection orders must be issued on the spot once the police respond to a domestic violence call. It is submitted that the police must remove the perpetrator, and a 14-day return date must be given for the parties to appear in court for a final protection order. Chair, the current position is that the protection orders are issued by the court, which is the institution authorized to deal with that. And as a result, it is our submission that to authorize the police to issue an on-the-spot interim protection order will require a policy decision and further an extensive consultation. And this could not be accommodated in the bill at this stage. And that will be our submission. Although it may make sense to consider allowing the police to do that, however, it will not be appropriate to deal with it at this stage, considering the policy issues that must be considered in relation to that. And this may also blur the roles of the police as opposed to putting that side by side with the role of the court, which is authorized to issue protection orders. So we will not support the inclusion of the provision that will authorize the on-spot issuing of the interim protection order by the police. Chair, the submission in relation to clause 5C is that it must be amended to provide that where it has been established that a previous protection order is in place and where the original application has not been finalized, an attempt should be made to hear the parties together. And as a result, a notice to show cause should be issued and the return date amended accordingly. The department's chair finds merit in the hearing of applications together. And the proposed provision, however, does not belong under clause 5C because this clause 5C deals with existing or reciprocal orders. However, the proposal can be accommodated elsewhere in the bill, particularly in clause 4(8). And the provision will read, the court must, where it is established that there is an application pending between the same parties, order that both applications be dealt with together and give direction as to the allocation of a date of hearing, and the notification of parties. Chair, there's a submission in relation to section 8.4b, which highlights the possible discretion created by the clause not to arrest for breach of a protection order. In response, Chair, our submission is that clause 8.5 requires the member of the South African Police to take into account various factors, including the risk to the safety, health, or well-being of the complainant or related person, the seriousness of the conduct comprising an alleged breach of the protection order, the length of time since the alleged breach occurred, and the nature and extent of the harm previously suffered in the domestic relationship by the complainant or related person. Therefore, Chair, factors that are listed in section 5B and C relate essentially to instances where the protection order has been breached. Therefore, the submission from us will be that only paragraph A and D of those listed factors be included and inserted in clause 3.1a as factors to be considered by the police when effecting an arrest. However, Chair, this clause should be read together with clause 4, which requires mandatory arrest for physical violence. The department is of the view that this should apply for a breach of protection orders too. However, the section should be aligned for clarity, which the department will take care of. Chair, the submission there is a submission, Chair, that a subsection 5C must be deleted because the length of time since the breach has occurred is irrelevant and presents the opportunity for the use of individual discretion and ultimately a failure by the police to arrest. The reason for the inclusion of the length of time in this clause is to ascertain the safety of the complainant in the context of the other factors and the need for urgent intervention on the part of the police. If a year, for instance, has passed, it could be argued that the situation may reflect that the complainant is not experiencing the level of harm. She may be if the incident has just occurred or recently occurred. The further submission, Chair, relates to subsection 5D, where the commentator does not or submits that they do not support the addition of that subsection 5D, since this information, that is the nature and extent of harm previously suffered, should be irrelevant to the consideration of whether the complainant is suffering or may suffer harm. Then the submission is for the deletion of this as a paragraph. Chair, although it is a factor, it should not be seen as a reason for not arresting where there has never been a previous harm suffered by the complainant. These factors can be dealt with in the directives or the standard operation procedures. In short, Chair, that factor is not should not be used as a reason for not effecting an arrest. There's a further submission, Chair, of the replacement or the substitution of the word national commissioner with the relevant station commander. This is to ensure a speedier response. We have taken note that the power to declare a person unfit to possess a firearm has been delegated down to the station level. As a result, we are in support of the submission received to replace the national commissioner with the relevant station commander. Further proposal, Chair, is in relation to the to clause 9.4, where it is proposed that a specific time frame must be determined within which the clerk of the court must inform the national commissioner of the protection order. The submission is supported, Chair. It is our submission that a provision requiring the clerk of the court to do so as soon as reasonably possible should be incorporated in the bill, so as to comply with the suggestion that the specific time frame should be included. We have considered to use the words as soon as reasonably possible, which is the clause that which is the provision that has been used in the bill and in the act in relation to the clerks of the court, and so as to avoid inserting a specific time frame like 6 months or any other specific time. So we are of the view that to say as soon as reasonably possible will be sufficient for these purposes. Chair, there is a submission that the court must allow the withdrawal of an interim or final protection order when it is convinced that the applicant is not at further risk of violence or abuse, and that the applicant's withdrawal of the order is not under duress. An affidavit to that effect must be filed by the applicant. Chair, this submission is essentially made in relation to clause 10, which deals instead with the variation and rescission of a protection order. The clause that we have amended, that is clause 10.2, requires that a good cause be shown for the variation or setting aside of the protection order. And we are of the view that there will be no good cause shown if there is still a risk of violence or abuse. Furthermore, Chair, the proviso to that clause 10.2 requires the application to be made freely and voluntarily. Chair, the recommendation that we have received is also that criminal proceedings ancillary to protection order should continue unless a complainant requests that the case be withdrawn. The reason for that be provided, and that must be documented. The withdrawal is not under duress, and there is clear evidence that children are not likely to be endangered should the case be withdrawn. Clause 18 has been amended to provide for mandatory prosecution. It is our submissions that criminal proceedings are not automatically withdrawn due to the variation or rescission of a protection order, unless the criminal case is also withdrawn. Chair, second last submission relates to the court's jurisdiction, where the submission is to include a place of study to extend the jurisdiction of the court. And we are, as the department, in support of that submission, as the reach of a protection order or in fact, what we are in support of is to say that the place of study will, in addition to the place of residence or business of the complainant, will be a suitable extension to enable the court to exercise jurisdiction to issue a protection order where that court has a jurisdiction over the area of the place where the complainant is studying. So the complainant will not have to go to the place or his or her place of residence in order to obtain a protection order. So the place of study will be a suitable extension to enable a protection order to be obtained by the complainant. Chair, the last submission is in relation to Section 13 of the Act, where it is proposed that in the case of a shared residence, documents may not be served on the other party to the proceedings. Chair, the risk to complainants sharing a residence is a well-recognized risk, and it may be advisable to request a complainant to be informed of the risk and be requested to indicate an alternative place of service, or to clearly indicate that the complainant may not be served with the protection order. And it will be our submission that the complainant must be informed by the clerk of the court. Chair, that is our responses, and I thank you for the opportunity to present this. Thank you very much.
Chairperson.
Chair, I have concluded my presentation. Thank you very much.
Chairperson, are you still there?
My apologies. My apologies. I muted myself. So thank you very much, sir, for the presentation. I think it's a much more improved presentation from the yesterday's presentation. I think the department did listen to our concerns. I will now note hands from members. Honorable Mufokeng will be number 1, followed by Honorable Horn, in that order.
Chair, it's Honorable Horn first. I'll be number 2.
It's fine. Honorable Horn.
Yeah, thank you, Chair. You must not allow the ANC whip to influence your decisions. But yeah, be that as it may. Yeah, Chair, I want to add my voice to you. Yesterday, I was very critical of the presentation. After this presentation, we really have a much clearer view of what the department's reaction is to the different presentations received during the public hearings. I want to just ask one question, and that's in relation to, if I understand it correctly, the amended approach to mandatory reporting. And I want to ask the department whether they wouldn't agree that it should be considered that an obligation be placed on reporting of all the domestic violence, but that in line with their amended proposal, only a failure to report on situations where the minors, etc., are affected, that only a failure to report those be criminalized. I know it will be in those circumstances only symbolic in nature, but it could send out a strong message that it is expected of everyone who has knowledge of domestic violence to at least involve themselves and not turn a blind eye. So I'm asking whether that has been considered, and if not, whether the department will consider that. Thank you.
Thank you very much, Honorable Horn. Honorable Mpuke.
Thank you very much, Chairperson. Chair, thanks. I think the presentation, as Honorable Horn is saying, is a very good one, and it assists us to actually be able to deal with issues. I want to note that on the chart, there was a message from Women's Legal Aid saying that they actually does not support the mandatory reporting, and they are quoted as supporting. I think that is one thing that the department should look at on the chart. And the issue on that I'm still going back to is on the economic abuse, or whatever that the department was saying, whether economic abuse or financial resources. But they are saying that it can impact directly on children in the home. But I would like to differ, and I think it's something that we can discuss also in the committee when we deliberate, because some families will find that a woman has been a person who's been taking care of the household, not working, and in other families they are never paid or be rewarded in any way. And when a situation like this comes to a family, we forget about that woman who doesn't have resources or not working. But it's something that we need to discuss, but we welcome your actually acceptance into that. The next one, Chair, will be on the, we really will, I think, support on the issue of the Warrior Project on the emotional pain that it goes to harm. That is something that is welcome too. Chair, on the issue of, I think it was on page 10, I still want to ask about the issue of the South African services. I think it's no, it's page 5. Yes, page 5, and it's on 10. That no mention is made of an obligation on the clerk of the court to ensure that interim protection orders and warrant of arrest are forwarded to the complainant and all that. But now, on the response of the department, it says this could form part of the directives. A social worker could be trained. When you talk about a social worker could be trained, when we are actually having challenges of training them now, having a challenges of training police officers now, what is it that we can have immediately without thinking? Social workers should be an additional. We should have another mechanism, and maybe something that we need to discuss. And we're talking about experience of things that we have seen. On the same page that I think is wise for Africa, they are saying the interim protection orders must be issued on the spot. And the response that is coming is saying, currently the responsibility is with the courts. We know that. To authorize the police to issue the spot interim protection order would require a policy decision. I think we are dealing with a bill to come up with better mechanisms. And maybe this is one subject to be discussed. We are not saying that it should be with the police, but there should be something happening. And I'm thinking that they are talking about experience in this regard. So as a committee, we should flag it. Some of us will have an input on that, on what to say about it. On the issue of SAWID, I think it's page 6. Okay, on SAWID, I've noted the departmental whatever response. However, this should be read together with clause 4, which requires the mandatory arrest for physical violence. I think this will be something that we also need to discuss, because there are a number of challenges therefore. Those are things that I'm mentioning, Chair, is because I want us to flag them and department to expect that we might ask for more, even if it's a research document. Now on page 13, about the SAPS on the national commissioner, or to the issue of is a national commissioner or the relevant station commander to ensure. I think this is the police officer that are saying that. And the department is saying that the department has taken note that the power to declare a person unfit to possession of firearm has been delegated down to the police station. I will differ, because the responsibility stands with the national commissioner. If you can find that the person we are talking about is a friend of a station commander, what do we do? Let us take it to the higher level and see who can be the relevant person. That one will be something that I wouldn't just take it lying low onto that. On the withdrawal, which is page 7, it was on the issue that was raised by, I think, let me see, on 94, or it was on Lisa. A court must only allow the withdrawal of an interim or final protection order when it is convinced that the applicant is not at further risk of violence or abuse. I think we know that some families will influence one. You'll be threatened with many things for you to withdraw. After that, you'll go missing or you'll die. I think this one, we need to look at it. We cannot just say it should be a right just like that. It's going to reverse the gains of the police officers going to arrest, a person going to court. What is that? Why should it reach there? If a person comes in, and most of the organizations said that they are against withdrawals of cases, and this is one issue that we must talk about because it's not easy. We know that influences of families. And Chair, I think the last part, it was on the issue that the court's jurisdiction should be extended to a place of study for the complainant. Then when it's not a place of study, it's a place of work, what happens? I think let us think about that one also. Thank you very much for the presentation. Was okay. Thanks, Chairperson.
Thank you very much, and thanks to the team. that has made this presentation on the corrections. I think we are really happy with what you have now presented. I think as we have given guidance even to the other presenters, try and create some options, even in areas where you disagree. There are issues that Honorable Mfokeng has views on, and I guess that there might be other different views. If you can create options so that when we process the bill, we are able to apply ourselves to those options. One of the options that you would need to apply yourselves to, I know that in your submission you are not in favor of, but it would be important that put it as an option we can apply ourselves to it, is the issue of temporal safety orders. We would like to apply ourselves to that one. You have indicated that it might be a policy issue. Can you bring all the relevant information at our disposal so that we can apply ourselves to that issue? It was raised by a number of organizations. We would want to apply ourselves and indeed see whether it is feasible or not. If it can also be reflected as part of the options that would be there in the text that we will receive for consideration. But thank you very much. Are there any other questions from members? None. Can I suggest, members, that because of time, we will deal with this one, which is domestic violence, last. I think Mr. Hank, might be ready for Friday. I think they've started working on the text since yesterday and today and tomorrow. So on Friday, we will start with the text from Mr. Hank. That would be followed by the second last presentation that we had, still on Friday. If we're not done, then we'll do it on Tuesday. And then next week, we will deal with the domestic violence. As we process the bill, because I was just thinking that it might be possible, it might not be possible just to think of all the constitutional issues that might arise. I think those that we can think of on top of our head and assisted by the researchers. I can see also Ms. Lust is here with us to identify all the constitutional issues, but some of them, as we are dealing with the bill clause by clause, we will keep on identifying some of them which we will refer to the Parliamentary Legal Services for their opinion as we are working on the bill. But we would really appreciate that by Friday, all parties should have identified the constitutional issues that they think that needs further legal opinion to be provided to us as we start processing the bill. I know that it's a lot of pressure on the department, but we do not have time, so we will start with a clause by clause or deliberations on Friday. If Mr. Hank can be ready on Friday and Mr. Robertson can be ready by Friday, and then next week we will deal with the domestic violence. Hopefully, if we get the legal opinions as speedily as we can still meet the deadlines that we set ourselves for. We were a little bit shaken yesterday. We thought that we would not, but I think the department has really done a good job. I think there is much more guidance now than and we feel much more confident that we can start dealing with the with the bills clause by clause. We do want to meet the deadlines, but meeting the deadlines would not and should not and will not be at the expense of the quality of the bills. If it means that we don't meet the deadline because we want to ensure that everything is right, then we won't meet the deadline, because a risk of the courts or even the president returning the bill back because it does not meet the constitutional muster will reverse the struggle against women or people who are in domestic relationship who are abused for some time. It would even be worse if the court find that the bills or the law is unconstitutional. Starting the process from scratch will reverse the gains that we would have made for victims of violence for many months or many years to come. So we have a responsibility to ensure that we do everything right the first time. Starting from Friday, we will be working longer hours, and I think the Secretariat should prepare another letter to the Office of the Chief Whip and the House Chair for us to meet during sittings next week so that we are able to finish the bills, or we move a while even if we don't finish the bills. We know that next week there might be a possibility that we will have to release few of our members for a short period to deal with the issue of the salary of the Deputy Public Protector. It would be on the order paper on Tuesday. And then I think some motions without notice, but we will deal with those logistics next week. We might need to go to the House and come back, but we need to ensure that we put the hours to ensure that we push the bills to the best of our abilities, and we see that where that takes us. But I think at this time I must thank all the people who have responded to our call to make submissions, both written and oral. I think the submissions have enhanced the quality of the bill that is going to come out of this committee. And thank the department and the other departments and for the collaboration that has happened since yesterday between the SAPS and the Department of Justice. It's important that government must work as one. That must never be undermined. The government must continue to work as one. When things come before us, they should have been processed properly. But I think the department has responded very positively. The quality of the bill and the quality of the responses are quite commendable. I know that most of you did not sleep. I could see Mr. Robertson that he has a bit of flu. We know that by the time we finish this bill, the DG will give you a very long, all of you will give you a very long break so that you can recover. But thank you very much to the department, to all the supporting staff of the committee and parliament, the people who have been broadcasting our meetings, the members of the media and the public that have been listening to us. This is still the beginning. We think it is still a long road until we pass these bills. People must bear with us. And to our colleagues, members who have been applying themselves very well to all the submissions that were made, not sleeping, going through through all the documents. That is why you could hear when the documents are not received on time, Honorable Nivot Dahan will be very frustrated. It's because of the commitment that members have in applying themselves into the work of Parliament, and we always want to ensure that nothing comes to the committee without us having read it and applied ourselves, because that is what we have been elected to do. So when we express our frustrations, it's because of our passion for the work that we are elected to do, and we hope you would understand. Thank you very much. I think for today we will adjourn now. The House starts at 3. We will meet on Friday, where we'll be starting with clause by clause and the deliberations on the bills. Thank you very much.
Thank you, Chairperson. I'm joining Constitutional.
Chair.
Thank you.
Thank you, Honorable Nuvot Rachen.
Chair, are you still there?
Yes.
I'm a little bit confused. So we're not going to go through the third bill, criminal matters and related. I don't know if maybe I'm asking for more work for myself, or did we go through it, or we're not going to go through it?
I think we did. Maybe the first, but I think we did. I think it was presented by Robert. Am I missing the point?
Chair, thank you. Mr. Robertson presented on criminal matters, and we have subsequently sent that document as well.
Yes. I thought I understood it that way, teacher. So, Honorable Rachen, it was presented. It was the first one today, and then we had to go back to the domestic violence.
Okay, yes, that's correct then. Thank you so much.
Very much, members. Thank you. The meeting is adjourned.
Okay,
Thank you,
bye.
Chair.
Thank you.
I'm joining Matemba Jele and Breitenbach.
Okay. Thank you very much. Thank you very much.